So, hello everyone, and welcome to yet another Case broadcast episode. Welcome to the Case broadcast brought to you by the team at Case Mastermind, where you can be part of a mastermind group. For more information, visit our website, casemastermind.co.uk. And it's hello from me, Patrick Twitchett, the Simplifier, and it's hello from my partner in crime.
It's Melvin Manning. Hi, everyone.
This week, we've got a wonderful guest with us, and that is the lovely Catherine Hyde. And Catherine, would you please like to introduce yourself to our audience?
Of course. My name's Catherine Hyde, and I am the owner of a law firm known as HooperHyde. And yeah, that's it. That's me.
Excellent, excellent. And where in the sunny UK do you dwell?
Based in Birmingham.
Ah, okay.
So right in the middle. Well, I suppose in the middle. Everyone says Birmingham's in the middle. It's not really, is it? Let's be honest. But we'll run with that. It's fine.
Yeah. Excellent, excellent. Right. So, and we're all going to talk about contracts and things like that. And I do want to make this clear before we start talking. This isn't contracts on people. So anyone that's looking for any sort of gangland bumping off or hitmen, you've come to the wrong podcast. This is going to be purely above board and legal contracts that we're talking about. So let's get that clear before we go any further. It's nothing to do with the Essex boys or anything like that. So, so Catherine, talk to us about contracts. I know I work with a colleague of mine, and me and him work well together because I can't stand contracts and reading contracts. I fall asleep after the second paragraph, whereas I'll give him a contract and he comes back and he's memorized everything.
Yeah.
And then I'll say, oh, what about that? And you go, oh, yeah, that's on page 5. Yeah, that's blah, blah, blah. And it's like, wow.
That's amazing. Does he want a job?
I'll let him know. I'll let him know you're looking.
Yeah.
So what do you look out for, and what do we need to look out for when we're reviewing contracts?
It kind of depends.
Can I just say, to start the ball rolling, Patrick, why do people need a contract?
Oh,
that's a good question. You don't need the contract. You don't have to have, and when I say contract, we're talking about written contracts, right? Because actually a contract, a legally binding contract, can actually also be verbal. So this whole adage of it's not worth the paper it's written on. Actually, it's not true. You can have a legally binding verbal contract. So Patrick and I could have a conversation, and I could say, Patrick, I'll do this thing for you, and he goes, great, I'll pay you X amount, and that's it. That's a contract. So the preference is always to have it written down, right? And I always say to clients, at a bare minimum, if you're not in a position to have like a actual formal agreement in place that you both sign, at a bare minimum, if you're having a conversation where you agree to something, just email it. Just, follow it up with an email that says, this is what we've agreed. This is what I'm going to do for you. This is what you're going to do for me. These are the timeframes we've agreed. And, this is what happens if we decide we don't want to continue. Bare minimum. Because then at least you've got something to refer back to if something goes wrong, if someone doesn't do something they said they were going to do. You're not stuck in a situation where you're thinking, well, hang on a second, I'm sure you told me on Tuesday of last week that you would do this. It's being able to prove it. So it's so much better if you have something in writing, even if it is literally just an email. And what I would even do is if your negotiations are within an email chain, there's lots of emails flying around, it potentially would be a bit difficult to really nail down what has actually been agreed. Again, finish the conversation with, right, as far as my understanding goes, this is what we've agreed based on this email chain. Can you please confirm? If I don't hear back from you within 7 days, I'll assume that this is agreed and we'll continue on this basis. So at the very least, exactly what it is everybody's expected to be doing, because that's where the disputes lie is, well, I thought it was this. Well, I thought it was this. you know, you get situations where something's even agreed in a formal contract, and then the parties, you know, vary that contract because they decide they want to do something else, and then they don't change the original contract. You know, it's all about clarity. So worst case scenario, if you have to stand in front of a judge and convince a judge that what you're saying is actually the, you know, what was agreed, what's the easiest way of doing that? Ideally in a contract, if not at the very least in an email written down to confirm that that's what the understanding is between the two of you.
To get that clear though, Catherine, I mean, you said there about an email, oh, if I don't hear from you within 7 days, I'll assume that this is correct. But ideally, you really want someone to just respond to that and say, yes, I agree with that contract, don't you?
Yeah.
And I know you were talking about verbal. The thing is with verbal is it's a bit of it's their word against yours.
Yeah.
So with all our technology today, I mean, even right now, we're recording this. To get that recorded, again, you've got that an evidence, haven't you, to fall back on?
Exactly. Because with a contract, there's 5 elements that you need in order to show that there's a legally enforceable contract. So if you can show that those 5 elements have been complied with, so it's the offer, so someone offers to do something for you, acceptance, the other person accepts that offer, consideration, which is basically there has to be something passing between the two of you. So I have to be doing something for you, you have to be paying me. It can't be one-sided. So even if you pay me a penny, there's got to be that exchange. It has to be there has to be an intention to create legal relationship. So in business to business scenarios or business to consumer, often that's very clear, it's implied, right? But sometimes there might be situations, particularly between friends, where, you know, there might not actually, it might just be a kind of very informal conversation, but one person might take it to be, you know, legally enforceable. The other person might think that it's just, you know, it's very informal. And then you have to have capacity. So the parties who are in that contract situation have to be shown to actually have mental capacity to enter into that contract. So, you know, children and vulnerable people, it's pretty much assumed that obviously that they don't have the capacity to enter into it.
Right. Yeah. That's really good. I've never ever heard anyone talk about the 5 parts to a contract, but that's really good. And that capacity at the end there, I remember back in the day, I have to admit to and confess to getting a little bit involved in double glazing at one point in my career. Oh dear. But from a genuine perspective, I went with a very good company.
Yeah.
But I remember at the time there was a thing on YouTube, and this guy had gone round to this elderly lady's house. And I think she'd had a level of dementia, but she could talk and she was okay. So if you spoke to her in the room, you'd think she's okay.
Yeah.
Anyway, she wanted her handle repaired on her door, and he ended up selling her a new back door. Then her son, who's quite savvy, then gets him back round, records the entire meeting and ridicules him how he's ripped off an old lady that all she needed was a £10 handle, and you sold her a door, and she's got dementia, and oh
dear, what a shame. I mean, it's difficult, isn't it, in those situations, because there's no way of knowing if someone appears to, you know, understand, because my understanding of mental capacity from a medical perspective, it's can the person, I believe, so don't quote me on this, but I believe it's can the person understand what you're saying in that given moment, and can they relay it back to you in a way that makes sense? So someone can have capacity 1 minute and then not have capacity in 10 minutes time. So it's really grey. It's a really grey. It's open to a lot of interpretation. So it is really difficult. And I think if you're ever concerned about someone having capacity in a situation, it's sort of niggling, I would probably take more steps to just make sure that you're confident that they actually do. Most of us, it doesn't even occur, particularly in a business to business setting, right? You know, most of us wouldn't even cross our paths or need to be a concern. But, you know, there are situations like the double glazing situation where if you're not 100% certain the person is definitely in a position to be making that decision, I'd get sort of a second opinion. No, that's some really good points. And oddly enough, around that, I
I'm going to say a relative because
Wanna give it
because
away?
it's someone in the family, and they basically had someone around to look at their roof, and then they had the guy around, and it was a lot of money involved, and he actually rung some children of that relative to ask their consent, but that person felt a little bit patronized and thought, well, I can make my own decision. However, he was trying to cover himself because she was quite elderly and he didn't want to be seen to be taken advantage. So
Difficult,
yeah,
isn't it? It is
it
difficult.
is. It is. Yeah. Very, a lot of areas when you deal with people in those situations, you have to be extra careful.
Yeah, exactly. Yeah.
But no, I like that. That's really good. The five stages there. So
Well, every day's a school day, right?
indeed it is.
May I just qualify something? From a point of view of business, Catherine, are we today talking predominantly consumer type contractual arrangements and situations, or can we go into commercial business type of contracts too?
I tend to only deal with business to business contracts. So that would be my preference, to talk about business to business rather than business to consumer, because consumer law is really complex. Like,
okay. So from a point of view of entering into a contract, your 5 points, is there a difference between you being in a meeting and agreeing something with somebody and shaking their hand, and obviously then making payments or having correspondence from a business? Who is the owner of the contract? Is it the person or the business?
So if it's a business to business context and you are representing the business, then it's the business, because ultimately there has to be a person that is capable of entering into the contract on behalf of the business. Now, often the person who is having the conversations about the contract is implied to have authority to bind the business. Sometimes there are situations where actually it can be argued that that person didn't have authorization to bind the company. You'll often see in contracts, or at the end of emails, this person doesn't have authorization to legally bind the company or something along those lines. So there's a lot of case law around this, because actually, it could be that it's the post boy that doesn't have authorization. Equally, if you're talking to a senior manager or perhaps a sales rep, that kind of thing, then the implication is from your perspective that actually they have authorization to enter.
I'm inferring that a business owner is sat in a meeting and they're talking to a supplier, a contracted supplier.
Yeah.
And they want to enter into an arrangement. Can the supplier go for that individual personally outside of any formal written or verbal contract?
Typically, no. There are situations in which it has happened that way, but it's rare because it's a business to business, negotiation, discussion, contract. So typically it would be the business that they would go for. So the limited company.
Because a lot of people do get caught out in that area, because you know what it's like when you're in a situation. I've read about them and heard about them on many occasions where they turn around and say, well, they've done the job X, Y, and Z, good, bad, or indifferent. I'm having to hold back funds because they haven't completed the project.
Yeah.
They've then taken that individual or whichever to court. And what they've actually done is they've gone for the person directly and not the company.
Yeah.
Because they said go. They said go, even though they're the business owner, and it was done for the business. And the judges, it appears to me, seem to go and side on the fact that that person said go, and it's your responsibility, so it's allowed. Is that correct?
I mean, like I said, that there are scenarios where that is possible, but you would have to convince a judge that actually the entity entering into the contract is the person, not the person on behalf of the company.
It's interesting.
So it could be that actually the argument hasn't been put particularly well in defense. That it could be that actually the negotiations did suggest that it was the individual entering into the contract, not the individual on behalf of the company. You know, for example, if there's no mention of the company anywhere, you know, I rock up, hey Patrick, I'm going to do this work for you. No mention of the fact that I'm a limited company, no mention of the fact that I'm even from a company, I'm just Catherine. Then there could be an argument that actually it's me that's entered into the contract, not the limited company. But it's so nuanced. Like, you couldn't say blanket, yes, definitely, or no, definitely not, because you know, it just depends on the situation you find yourself in. Hence, circling back to why it's always better to have it in writing, right? Because it's very clear then who the parties are and what you've agreed to. Verbally is fine, it's just as enforceable, but so much harder to prove what the terms are.
Yeah.
Interesting.
I mean, and it's funny because Catherine, Melvin normally asks those questions because he's
Had a scenario.
there's something going on there. So
Yeah.
if anyone is watching this broadcast and you've done some work for Melvin or you owe Melvin money, watch out because he's coming for you. He will find you and he will kill you.
and I do live in Essex.
Yeah, that's right. So there is another.
Is that where all the
type of
hitmen live? Is that why?
Yeah, that's it. There's another type of contract that Melvin will be getting there.
It's situation. To be honest, it's situations I have found myself in, and I mean, nothing's ever happened, but it's just the fickleness of law, where you don't really know where you stand.
Yeah.
I mean, you know, we can then move on to, for argument's sake, I don't know whether it's on your agenda there, Patrick, because it's obviously, I think it's on the notes somewhere, but you know, contracts, employment law. Yeah. Contracts between an employee or a third-party supplier and a business. Yeah. You know, he said, she said moments.
Yeah. I mean, there is a legal requirement. I'm no employment law expert, but there is a legal requirement to actually have an employment contract between employer and employee. Like that's bare minimum you have to provide for your employee.
So let's come back to you though, Catherine. Where would you say your specialism is as far as, you know, within the world of legalese? Where do you kind of find yourself?
I mostly deal with commercial disputes. So I fix. Am I allowed to swear?
Well, a little bit.
Patrick,
close your ears.
I fix the shit show when it's gone wrong, basically. And this is why I'm so keen for clients to have contracts, because so many disputes could be avoided or dealt with a lot easier had they got stuff in writing. So I deal with commercial disputes. So that can be things like breach of contract, debt recovery, directors falling out, directors being disqualified, shareholder disputes, you know, sort of like minority shareholder stuff, any kind of commercial
failure to deliver on scheduled time,
so that would be classed as a breach of contract. So that sort of thing. I help, and my specialism really in that regard is actually helping to fix something quickly and painlessly as possible. Like that's sort of where my sweet spot lies, really, is get in, fix it, get out, because nobody wants the lengthy, hideous, drawn out process of, you know, of court action, because it can take, you know, 18 months, 2 years to get to a trial, and it's slow and painful. And unfortunately, once lawyers get involved, it's even more slow and painful. Like it's just
painful mentally, but more importantly, financially.
To the pocket. Yeah, exactly. That's true.
Yes, indeed. And so the thing is here, so, you know, on contracts and all this thing here, Catherine, and involving yourself, when someone, you know, we're talking about here, you know, someone comes to you with a dispute, but ideally, the ideal scenario is that someone comes to you before that and says, I've got this contract, Catherine, and I just want you to have a look at it. And I take it that's something that you can do as well, isn't it?
Yeah. So if it's not a hugely complicated one, then I will typically look at it, because obviously I've looked at many contracts from what we're missing here, what's gone wrong. So actually I bring a different perspective than a commercial lawyer necessarily would. But I do also have commercial lawyers within the business who can look at the sort of hugely complex, you know, software as a service type, you know, or telecoms or something that's quite nuanced and quite complex. Then we have lawyers that will do that as well. But my ideal scenario is actually they don't ever really need me, to be honest, because of the fact that I would rather they get stuff looked at from the beginning than they needed me to fix it when it went wrong in the end. Like that is
Yeah.
always my preference. I'm really keen on educating people on the importance of having something in writing. This is what I always say. I don't really even care if it's not a formal contract, just something in writing, so that if you ever do have a situation where you disagree, it's really clear because you can refer back to it.
Yeah. And we're only talking, you know, and I know Melvin made a hint towards solicitors' hourly rates earlier,
Yeah.
but you know, it doesn't take a huge amount of time for a solicitor to read a contract, whereas it probably take me about half a day. You could probably do it in half an hour.
Yeah.
And so the cost implication of that is what I'm trying to get to, is that it might be tens or, you know, not really hundreds of pounds just to get something like that reviewed. And whether that's a big or small contract, that small amount of money spent at the start to get a legal perspective on it, and just to say, oh, hang on a minute, you should really dot that I and cross that T over there, could save you so much time and aggro later on that £100, the return on investment of that you'll never see because you never have the problem, is really exponentially worth investing in, isn't it?
It's difficult because I always describe commercial lawyers as insurance policies, right? You might never need that contract. You might sign it and never have to look at it ever again, right? But that, you know, X number of hundreds or a couple of grand spent getting a commercial lawyer to look at it, to make sure that you understand it and that you understand what you're getting yourself into. I've got a bit of a story about this, actually, I'll come back to, is so much better than having to deal with litigation at the other end if it goes wrong, because that will probably cost you 20, 30, 40 times more, way more time, way more stress. Like much better to just go, hey, Catherine, I've got this agreement that I'm going to enter into. Can you just give it a look over to make sure there's nothing in there that I wouldn't want to agree to? Absolutely fine. Versus, hey, Catherine, it's all gone horribly wrong. I'm super stressed. I don't know what to do. I don't really know what was said. You've now got to dig out all of this paperwork for me to be able to figure out if there's anything that we can do and what that looks like. So much better to have done you know, the first thing than the latter, right? I had a scenario recently, well, I say recently, probably like 6 months ago. A client came to me and said, I'm going to be entering into a joint venture with somebody. We've basically pretty much agreed terms, but now he sent me this joint venture agreement. Can you give it a look over? Yeah, absolutely. Read it, and I've basically said to him, I was like, do not sign this contract as it is. Number one, it's really heavily, you know, weighed towards him. And I said, and secondly, there are things in here that you just won't want to agree to. Just don't enter into it. These are the things that I would go back to him and say you want to change. And if he doesn't want to change them, then you kind of know that you know it's perhaps not going to work. Well, he went to him and said, these are the things I want to change. These don't reflect what we talked about. And he just point blank refused to change them. It was a blanket, no, if you want to do this joint venture, these are the terms on which we do it. End of discussion. And my client came to me and said, oh, do you know what? Actually, I'm so glad I got you to look at it, because it gave me a bit of insight into what it would be like to work with him. And I realized that actually there was no negotiation, there was no flexibility. It was his way or no way. And I realized that I didn't actually want to then do a joint venture with him. So if he hadn't come to me, he'd have signed that contract, not really looking at it, not really understanding it, and then found himself in a situation where he probably would have wanted to have gotten out of it, you know, within X number of months, and perhaps might have found himself not to be able to. So yeah, always get it looked at. If someone sent you a contract, don't just sign it.
Yeah, so true, so true. And I think in the modern age, you know, everywhere's got a contract. You know, you get an Amazon account, and then it goes, here, read this 75-page list of things, and then tick this box.
And you're not going to, let's be honest, who reads the terms and conditions when you sign up to a website? I'm sure 99% of people don't. No. Because the expectation is it'll be reasonable. And as from that perspective, you're a consumer, and there are way more consumer laws in terms of protecting the consumer versus the business. So you can, I mean, this is not legal advice, right? But you can comfortably say these terms and conditions are probably fine without me needing to read every single word of them. Equally, the nature of what you do on Amazon, it's unlikely you're going to end up getting into a dispute. It's not beyond the realms of possibility, right? But it's unlikely. So, you know, I think there are scenarios where people just don't sign them, and it's fine because they never need to worry about it.
Well, there are stigmas, as obviously we've alluded to earlier with the reference to costs, which you mentioned, Patrick. And the thing is, you know, people will turn around and say, God, I can't afford to pay a lawyer to read that.
Yeah.
I can't afford a lawyer to this and that and the other. I mean, how can you remove that stigma without obviously qualifying the fact that it's a great idea? It's something you must do, because if there's £1,000 bill attached to it, people will turn around and say, we'll take a chance.
Because that £1,000 bill might actually
they'll do a walk-in at the whatever lawyers down the road for 50 quid, and everything will go pear-shaped.
Yeah, I think there's a few things kind of to cover off there. The first one is, can you afford not to get a lawyer to look at it, right? Because ultimately, you know, it might be fine. And if you can read a contract and comfortably say, actually, I understand that, it makes sense to me, there's nothing in there that I'm concerned about, or, you know, it might just be you've been running your business for a long time, you know, you've signed these types of contracts many, many times, it's not an issue, right? Versus maybe you're growing and you've suddenly got a really big contract or piece of work cross your path. You really probably feel a bit uncomfortable about signing it, because you just think, oh, what liability am I opening myself up to here? Actually, for that peace of mind, that money is well spent as far as I'm concerned. Because like I said, with insurance policies, not, you know, you can't avoid every single scenario in a contract. No contract is 100% perfect, because you can't predict everything that's going to happen. But from my perspective, it's always a case of, do you want peace of mind knowing that what you're signing is what you expect it to be, as opposed to you're signing something with a little bit of trepidation and, oh, I don't really know what this says, but I'm going to sign it anyway and just put it to one side and forget about it. Versus then you've got probably having to spend 20, 30, 40 times more to fix a problem at the other end. I know which one I would choose, which is a peace of mind and a cheaper bill, than the sort of niggling worry constantly that there's that thing you signed, but did you really understand it? Is there anything in there that you perhaps thought you understood but wasn't actually what you thought? Because often these things are open to interpretation. I mean, that's why we have litigation, because I say something says one thing and the other side says it means another.
And when it does go wrong, it's not necessarily the money side of it that's the worst part. Like you alluded to earlier, it's the stress, but also it's the time element. You've got to get all this information together. Then if it goes to court, oh my goodness me, then it's like horrendous, isn't it?
Because at the point at which you're deciding whether or not to go to court, you've basically got to go, right, am I prepared to commit this time, this headspace, this money to take this case forwards, when there is no guarantee that I'll win? No. You know, you can prepare a case brilliantly, but you never have 100%, you know, chance of success. It's just not how it works. Versus, versus actually, you know, do I have to sort of, you know, squash my ego a little bit and say, do you know what, I'm not going to take this forward. I'm just going to have to suck up the fact that it went wrong. And, you know, neither of those choices are great. We're human beings, right? We hate the idea of losing or having to let go of something when we feel like there's been no sense of justice. You know, it's not a nice choice to have to make, really.
Definitely not. Not. So I think we've covered a lot there about what to look out for when reviewing contracts. I mean, is there anything else that we've missed off, do you think, or have we covered most of what we need to look out for, do you think?
I think the biggest things for me are, it's rewards. So what are you getting and what are your responsibilities? So what am I expected to do? And when you're reading your own contract, what am I expected to do here or deliver? And what's my liability? So, you know, there's often a liability clause, you know, and sometimes they're like £1 million. And you think, well, hang on a second, this contract's only worth 500 quid. Why have I got a liability for £1 million? You know, it's those kinds of things. Do you understand what you're actually potentially opening up yourself up to? And then in an ideal world, it's, how do I bring this contract to an end? So termination. How do I, if I don't want to continue, how do I stop it? Because you can end any contract, but if there's no specific termination clause in a contract, or no agreement around termination, then the only way to terminate, other than, you know, someone not delivering something, and, you know, the kind of complexities around repudiated contracts, and, you know, I'm not going to get into it, both parties have to agree to end it, typically. So the ideal is that you have something in writing that says, right, I can terminate this contract if you don't deliver this thing within 14 days, or, you know, something along those lines, depending on the situation you find yourself in and the reasons why you would want to bring it to an end. Because often people find themselves stuck in situations. And just really quickly, I do want to make this point. If someone doesn't deliver on a contract, that doesn't give you the automatic right to not deliver your side of the bargain. You would actually find yourself they're in breach of contract, and so are you. So that just brings it in a whole other complexity and scenario. So what you could potentially do, again, this isn't legal advice, but what you could potentially do is say, you haven't delivered on this, so I'm withholding payment until you deliver. This does not mean that this is an automatic breach of contract, or something along those lines, just to make it clear that actually you're not saying that, you know, you're just not going to deliver and that's it. Because it's really important that you don't find yourself in breach of contract just because they are.
Yeah.
So it's really difficult, because obviously if someone hasn't delivered, you're like, well, I'm not paying you. Why should I pay you? That's ridiculous. But it does happen. So just be careful.
Okay, so Catherine, I'm a brand new business owner. I've just come out of uni. Got a fantastic idea. I want to set myself up in business.
Yeah.
At what point should I talk to somebody like your lovely self?
In an ideal world, straight away. But I get that most people don't have the money. So I don't particularly like them, but there are sort of template, you know, businesses online that do have, you know, template terms and conditions, for example, that you can purchase. They're typically drafted by lawyers, so you can buy them. Just make sure that you understand them and that they reflect your business. Yeah,
but from a point of view of looking after, you know, you as the expert that you are, do you offer a package to somebody that is a greenhorn, basically?
Yeah, so I mean, we do have fixed fee rates. We do have, you know, even for litigation, I do fixed fees because I hate hourly rate billing, and I hate
if I meet you for the first time, will you charge me, or will you give me a little bit of time?
No, I can't advise without you being a proper client, like, because you wouldn't have the protections that you would expect to have if you weren't a proper onboarded client. I could give someone, you know, I could signpost somebody somewhere to, you know, a website that I like that has some template documents on them, but I can't give legal advice because you're not a client.
Wow.
Is that a law society thing, or is it just
the SRA, so the Solicitors Regulatory Authority? It's all about sort of upholding, putting the public's best interests first, and upholding the regulations, which is basically around, you know, ethics and, you know, not bringing the industry into disrepute, so not doing things that would make people think badly of the legal profession.
Okay, because obviously most people wouldn't know that, Catherine, so I think that's really important information to get out there.
Yeah, definitely. Although, I mean, in saying that, someone can still sit down with you and say, look, Catherine, this is what I've got. You know, I know you might not necessarily be able to advise me on it, but look, have a look at that, review that, and then let me know, you know, where we need to go. You can advise on that, can't you?
Yeah. So I do an initial consultation that is free because So because a couple of things. First of all, if you don't necessarily know me and perhaps you've been recommended to me, you need to meet me and decide whether or not you think I'm someone you can work with. Because if that, you know, that relationship requires so much trust that if you don't feel like you can trust me, we can't work together. But equally, I need to meet you to make sure that I can communicate with you in a way that I feel is valuable, because there's no point in us having a working relationship if actually I'm explaining something in a way that you're just finding really frustrating and you don't feel like you understand, and it's really jarring. That helps nobody. I also need to make sure that it's something we can help you with, and I can't do that if the first conversation is, right, give me your money. Because why would I charge you for something I don't know I can do yet? So it's like a scoping call, really. It's, do you like me? Do I like you? And is this the kind of work I can do for you? And what would that potentially look like? So I typically ask for sort of the bare bones of maybe the email conversations, or give me a bit of a breakdown of what's happened, send me some documents. I'll have a really quick look through and say, right, actually, from a really quick look, this is a very clear breach of contract. This is what we could potentially do going forward, but it's not legal advice. This is what we would draft a letter before action based on XYZ. This is the process that we would take forward, and this is how much it would be to do that. So there's always a scoping call, because we need to check each other out, right? Like, it's that simple. I don't want to work with people who are finding me frustrating, because that doesn't serve them. I'd much rather say to them, look, I don't think this is something we can help you with, or I don't think that we're necessarily the right fit. Perhaps what they do is too technical and we don't have the expertise. So I'd much rather send them somewhere else, or say to them, you need to find another lawyer because we're not the right person for you. Life's too short, right? to spend it working with people that you find frustrating. And it would be a real shame when, it's like it's like your doctor. You need to get on with your doctor, otherwise it's just a really frustrating, aggravating relationship. Yeah. It's the same thing. You need to trust me, and you need to have faith that I'm going to do the best job for you. And you need to be able to open up to me in a dispute situation, right? Sometimes you've got to be able to say, do you know what, I balls this up. I'm just, and if you don't feel like we've got that kind of relationship, it's not going to work, because I need to know. Yeah. I need to know what's happened realistically, even if it's something really bad, so that I can then say to you, there's no way we can get you out of this. Best case is this, and this is what we'll do.
Mm.
Yeah, sure.
People do put themselves in big holes, don't they?
Yeah. And we've all done it, right? Even I've done it. I got myself in a situation where, it kind of wasn't my fault, but I paid for some leads, right? I thought, right, I'm gonna see if this works. So this company had approached me and said, we're trying to get into the legal profession. We're doing a one-off, pay for 10 leads to see if it works. Now, normally their business model is it's a minimum 12-month contract. You pay a set amount every month and you get 10 leads every single month. But obviously, as it was a one-off, it was a 1 month thing, basically. They sent me the leads. They were pretty rubbish. There was one that turned into paid work, but to be honest, he just wasn't the right sort of client for us. So didn't think anything more of it. Just went on my way thinking, well, it's a one-off, I'm not going to carry on. Next month rolls around, they take another sum from my account. I was like, whoa, hang on a second. I didn't agree to that. Took me 2 weeks of emails to convince them that they'd misrepresented to me what they were selling me, and that actually what had been agreed on was just a one-off 10 leads, and that was it. But it took me ages speaking to 3 different people to get them to concede that actually I was right and they needed to send my money back. Now, I deal with that all the time for clients, but when it was for me, it was so personal. I was so angry about it, because I was like, hell no, that is not what was said. If you've got call recordings, dig out the call recordings. I've got emails here very clearly setting out what's happened. So it happens to lawyers. It happens to us all. Sometimes it's all about interpretation. So as far as they were concerned, their standard way is a 12-month minimum, monthly rolling. So that was just the stock answer I kept getting from them. And I was like, no, that's not what was agreed. But it is, it's emotional when it's yourself. You can't help but get frustrated and angry, because you're not listening. And this is actually what's happened. So
yeah, but it's that magic little word, isn't it? Con.
Yeah.
It is a con.
Yeah. Like, they get you to try.
If you say that, you're blaspheming them, aren't
you? Yeah.
Yes, indeed. So in trying to sum this up a little bit here.
Yeah, good luck with that.
Yeah. Indeed. I'll send you an email.
You're sounding like a lawyer now, Patrick.
Yeah. You need to respond to that to confirm you've received it.
In summing up.
Yeah, but including in someone listening, the listener who's listening to this now, what should they be in? We've covered a bit of what they should be including in their own terms and conditions. Is there anything else that they should be considering? Because at the end of the day, they want to ensure, if they're a business or whatever, they want to ensure that they get paid. Now, at the end of the day, that's what you want, isn't it? You're going to do a service, and generally, you're going to get paid for it.
Yeah.
And I know there's people listening that are the other end of that. They might be taking out a service, but at the end of the day, is there anything to look for? Is there anything, particular things to make sure that you cement in?
I mean, I would always suggest to clients, where possible, to either get payment up front or at the very least some kind of deposit. I think sometimes what happens is people don't realize that they can ask for that. They almost think they're supposed to deliver first and then get paid. But actually, you can agree anything, right? As long as everybody agrees. And I would always say to people, particularly when you're first starting out, because I think often businesses fail because of cash flow.
Yeah.
And if you had actually got the payment up front, or at the very least a deposit, so that, so for example, anything under £1,000 for my business, it has to be paid up front. It sits in the client account until I raise an invoice. And then as soon as I raise an invoice, it gets transferred into office account, which is basically my money. So until I raise an invoice or have done the work, the money's still the client's money. You can have it back at any point in time. It's just that I'm holding it on trust for you in the client account. Anything over £1,000, it's like, right, well, how much more over £1,000 is it? Can we take 50% up front and 50% before delivery of the final piece of work, for example? Or, I'll say to a client, right, we're going to be dealing with this case for the next 12 months. Let's agree that you'll pay X amount every month. And for as long as you're paying that, I will continue to work. Because so many scenarios happen where someone does a load of work and then never gets paid for it. And, your business will fail because you've got no money. Well, that would be a real shame for that to happen if actually you just flipped it and got paid first, or got paid a deposit. So at the very least, you got 50% of it and didn't feel quite so galled that you've done 100% of the work, but got zero, right? So I would always suggest to people. And then often it's things like not understanding that you have rights that you can enforce. So you saying to the other side, you haven't delivered this, doesn't have to mean two things. It doesn't have to mean that the relationship has to end. And it also doesn't mean that it has to be contentious. You can have a grown-up conversation with someone and say, look, I'm not happy with what you've delivered. I'm not, this isn't what we'd agreed. This is what I say we said we would do. So can we have that conversation? Enforcing your rights doesn't have to be this huge, scary, argument all the time. And I think sometimes people don't know that, and they just sort of go, oh, no, I'm not going to do that. It's fine. I'll just forget about it. Well, that would be a real shame if actually you've done a bunch of work and then you're not happy with it, or they're not happy with it. Just have an adult conversation.
Yeah. And again, that's the first port of call, rather than chucking a CCJ and all this sort of stuff in the ring of county court judgment and getting it all involved in the legal service, because again, that's money and time, isn't it?
Yeah.
But
And so many disputes could be avoided if you just had a conversation with somebody.
Yeah, that's right. And I know sometimes conversations break down and then it gets more difficult, or one of the parties is being very evasive and just pinging an email and all that sort of thing.
Yeah.
But there's also, where does mediation come into this? Because that's in between the two. It's in between the conversation and going full on legal battle. There is this mediation. I know there are some solicitors that specialise in just mediation.
Yeah.
But where does that sit in amongst all this, Catherine?
I mean, you can mediate at any point, but both the parties have to agree to mediate. Like, you can't force someone to mediate.
Right.
But I always favour mediation over issuing a court claim, because it can get dealt with in a day, typically. Whereas a court claim can take months and months and months. And ultimately, so with mediation, it's about getting the parties to come to agreement. Whereas with court action, it's standing in front of a judge and letting a judge decide. So often mediation can feel like that you have a little bit more justice because you've had a bit more control over what's gone on, because you're able to say yes or no, I do agree with that, I don't agree with that, or yes, I'm prepared to concede it. Whereas obviously with a judge, it's judgment. It's one person saying what they think has happened in this scenario. So you can mediate at any point. You can mediate right at the beginning. You can even agree to mediate a month before trial if you want to, if you think there's value in it. And then, you come to an agreement and the trial doesn't go ahead. Preference is obviously to do it early doors because, like I said, you can get it done in a day, mediate in a day, get a settlement agreement signed, job done. Parties are happy, everyone moves on. Way cheaper than court action.
Yeah. And you've got an intermediary in
Yeah.
that process as well, haven't you? That
Yeah.
it's not just you versus you, but it's someone in the middle with a bit of common sense and a bit of legal knowledge to say,
Yeah.
well, actually, this and actually that.
Yeah.
And I think
So the mediator doesn't advise, but they will go between the parties and help them understand each other's position to then be able to help them come to some kind of agreement. Now, it could be that you might agree on 9 things and agree that one last thing is something that you want to deal with at trial, for example. But the mediator is there to mediate, to basically try to get them to see each other's perspective and ultimately come to some kind of compromise within it. So it's hugely beneficial. I don't know why more people don't do it. I think lawyers unfortunately don't typically push it or suggest it because it doesn't serve the lawyer ultimately, because if I said, oh yeah, mediate, and then it got settled, well then that's work that is no longer there for me. So it's really difficult because actually we are supposed to obviously put the client first, but there are lots of lawyers out there that won't push alternative dispute resolution because it doesn't serve them, and that's not great. So I think it's important that people know that there are alternatives to issuing a court claim.
Yeah. Well, you're starting to get into the morals and ethics there, aren't you?
Yeah,
Very much so.
And that's why it comes down to trust, right? Because you have to trust that lawyer's putting your needs first, not theirs.
Yeah. No, but that's good, and that's really interesting. And I think I don't know about you, Melvin. I've definitely picked up a few points from today, especially things that I wasn't really aware of, and I think that's been really helpful.
In all my years of being in business, this has been, let's say, most enlightening because things have moved on, things change, people's morals and objectives have differed over the years. No, I think it's a breath of fresh air that Catherine's enlightened us, our audience of 1, I think it is out there. Amazing. And hopefully, they're a little bit more informed, and that's the most important thing about our podcast is that people get informed.
Yeah, absolutely.
The naivety of individuals and the fear of individuals, it's quite high in this day and age.
I think people don't typically also approach lawyers because they think that they're, it's for so long it's been this slightly secret club, right? That no one can, you can't come in. This is our secret club, and it's like actually it's just a job. We just have a particular skill set that we can help you with, and I think it's breaking down those barriers.
Yeah, no, I think that those barriers are quite high right now, and obviously the world we're living in doesn't help.
Yeah.
You may have seen me go a bit quiet for a couple of minutes just a moment ago, and the reason is that secretly tapping away on the keyboard, I was recommending you to somebody that I know that may need your help.
Oh, amazing! Well, thank you very much. It's very kind.
So there you go, live in a podcast,
a live recorded referral going on there.
Love it, love it. More of those, please.
It may come to nothing. I don't know what position they're in, but it might not happen. But this conversation, from my point of view, has encouraged me to do that.
Amazing. Well, thank you. I appreciate it.
Yeah, so, Patrick, when you get it, no, I'm joking.
So, Catherine, if there is anyone listening and would like to get hold of you and like to get a bit of advice or discuss something with you, what's the best way for them to get in touch with you?
Well, if I'm typically hang out on LinkedIn. So if you're on LinkedIn, that's the place to find me. But obviously I have a website, which is www.hooperhyde.com, which is HOOPERHYDE.com. And then the main email address is hello@hooperhyde.com. So those are probably the best ways to get hold of us. Just drop us a message, tell us what it is you need, and we'll tell you whether or not we can help. And then we'll set up an initial consultation, usually by Zoom, or you're welcome to come to the office and have a chat.
Yeah. Okay. And from our previous conversations, you're Catherine with a C, not a K, aren't you?
Yes, Catherine.
And you're a Catherine. You're not a a Kathy or a Kath. So
Yeah.
just to let anybody know listening,
Yeah.
don't come in with those remarks, please.
Call me a Kathy or a Kath and it's a blanket, right? I'm not working with you.
There's your
The only people
contract.
that
There's
call
your
me-
contract, listeners.
Yeah, the only people that call me Kath are my oldest friends. So my friend who I've known since I was 11, her and her family call me Kath. I don't know why, because they're the only people that have. And then I had some school friends that used to call me Kathy, and I hated it. Hated it. I've never been a Katie, and that's a whole other story for another time. But yeah, it's Catherine. It's just Catherine.
Plain and simple. Excellent. No, that's brilliant. So I think we can finish off things there. So I will again continue to tell our listeners to carry on listening out, listening up, and listening in.
Nice.
See, there we go.
Yeah,
And
Patrick's party piece, we love it.
yeah, there we go. I spent months practicing that.
Taken 30 years.
Yeah, 30
of this discoordination.
Yeah, I couldn't do the Ted Rogers 3-2-1 properly. So I had to do something
She's
else.
too young to even know Ted
No,
Rogers is.
Yeah, no, I do know the 3-2-1 thing.
Oh goodness
What is
me!
it? 3? No, that way. Hang on.
Yeah.
You know what I mean?
Yeah, 3-2-1. Yeah, that's it. Yeah.
I'm just gonna go like that. It's so quick. You don't even see me doing it.
Patrick, he speaks to his dusty bin all, pretty much every day.
Dusty bin. Oh my
Just-
God, that's a blast from the past.
That is a trip down memory lane, and the cryptic clues that were completely opposite to what anyone on earth would ever
Yeah.
think. They were the most cryptic clues.
So
like
cryptic.
code, weren't
Makes
they?
sense. Yeah.
Okay, so thanks very much. So thank you. It's goodbye from me, and it's goodbye from my partner in crime.
It's goodbye from me, Melvin, and I hope you're all having a great time. And if you're not, keep smiling.
And a goodbye from our guest today, Catherine Hyde. Thanks very much, Catherine.
Thank you for having me.
To continue to listen out, listen up and listen in to the Case broadcast, do hit the subscribe button to receive reminders of all our new episodes.